24 CV 52569, 25 CV 16784, State of Oregon versus Douglas County excuse me, Jill Bong versus Douglas County School District times set on a hearing regarding motion to compel. That I should mention, I believe that there's a motion, well, hold on one second. So there's a subpoena in each case, and if my recollection serves without looking in the 52569 case yet, there was a motion to compel in 25 CV 16784 regarding the subpoena. The court granted that subpoena, that motion to compel. And then after the fact, Mr. Mersereau brought it to the court's attention that the motion was never served on Mr. Mersereau, and Mr. Mersereau didn't have an opportunity to object. And so, Mr. Mersereau, the first question is, does your client have standing to object to this?
Yes, Your Honor, because it seeks communications with me and with the district.
Okay.
And just for the court's information, I'm not aware of a subpoena or a motion to compel in the 24 case. I thought we were here on the 25 case only.
I think, well, that would be the same issue. I don't think that it's, I don't know that, I believe there's a subpoena in that case as well. Ms. Bong, isn't that correct?
I'm not sure which case it is. I believe there is some subpoena for something else, but I don't have that in my records in my possession right now. I was not prepared for that. I was only prepared for this case.
Hang on a second. In 24 CV 52659, there is a motion to compel production of documents pursuant to subpoena ducis tecum. That was filed back in July. And I believe Ms. Bong recently filed a notice. Listen, there's been so many things filed in both of these cases that are overlapping and quite frankly confusing to the court that I'm trying to make sure that I'm representing accurately what we have before us, because there is a motion to compel documents pursuant to ducis tecum in 24 CR 52569 as well. And it doesn't, and hang on a second. It does not appear to me that Mr. Mersereau would have any reason to know that that motion is pending, precisely because it doesn't, there's nothing to suggest that he's been made aware of it.
Yes, both motions to compel subpoenas were only sent to the subpoena person as required by ORCP 55.
Motion to compel, but Ms. Bong, you filed a pleading in a case where there is a opposing party that doesn't have notice or they don't have any way to know that there is a motion filed.
They were aware of the notice of subpoena. The motion to compel does not, it's not targeted at the party, it's targeted at the subpoena person according to ORCP 55. ORCP 55 requires the subpoenaed party to be informed of the motion to compel.
Show me where it says that.
And that would be, 1 second here. I believe it's ORCP 55. A sorry, 1 second here.
In particular, I want you to point me to the carve out that says you don't need to serve it to other parties of this action.
So I believe it's
A7AII says a copy of the motion to compel must be served on the objecting party.
correct.
Yeah, that's an
And
affirmative
it
duty
applies.
to and there is no, it doesn't imply anything. It says you have to serve the objecting person. It doesn't relieve you of your duty to serve a copy on other parties of the action.
If I fail to do that, then I do apologize to the court and the opposing party. But regardless, there is no real prejudice because the opposing party has no, other parties have no standing to oppose the motion to compel.
Mr. Mersereau?
Well, again, Your Honor, this is the first time I just looked at that second motion to compel in the 24 case, or in the 25 case on the ESD, and it seeks the same material. It seeks communications between me and my clients. It seeks communications between me and my insurance client. It seeks communications between the defendant, the school district, and the insurance client. These are
And
all.
Mr. Mersereau, you're saying you have standing to object because these are privileged communications?
Yes, that's correct, and irrelevant as well.
Well, so let me say this first. There will be no more filings in this case that are ex parte unless they are specifically delineated as allowed to be ex parte by statute or some other authority. I am setting aside the previous order on the basis that it was done erroneously, or granted erroneously by the court in ex parte fashion. Ms. Bong, do you want to be heard on the issue of Mr. Mersereau's objection based on privileged communication?
Yes, Your Honor. For one, he has no standing on the issue. He has asserted attorney-client privilege, but the information I request from the insurance pays of Mr. Jensen is claims notices submitted on behalf of Douglas County School District for defense, legal defense coverage, etc. These are public records documents which the school asserted they had no knowledge of such documents and would prove that they do exist and that they erroneously or purposefully withheld them from me in the public records.
So you're saying that I think I'm going to try to refashion your argument. I think what you're telling me is that because these are public records that Mr. Mersereau or his client has failed to produce, that they are now waiving privilege, and these matters are relevant because they're public. I mean, they are relevant because they're public documents.
They are relevant,
public records.
yes. But no, they're not subject to attorney-client privilege because these are communications between the school district and its insurance. The insurance is not an attorney, and therefore they do not have the privilege of attorney-client privilege.
Mr. Mersereau, is there some reason why it would be erroneous of the court to grant the motion to compel with exception of privileged documents or documents otherwise identified as irrelevant?
Well, I think the entire subpoena, both subpoenas seek only irrelevant documents, Your Honor, because they are only aimed at this issue that Ms. Bong has with me representing my client. Nothing that is sought in either subpoena has anything to do with Ms. Bong's public records requests, which are the subject of these two cases.
I need to seek some clarity. I need to seek some clarity here because one of the things that I am not understanding is how Ms. Bong, in this through these proceedings, you are objecting to Mr. Mersereau's representation of the school district. You don't have standing to do that now. But one of the things I want to be clear about is documents, or should I say, are documents that demonstrate that relationship public records, or are they privileged documents? That's the thing that is on the back of the court's mind.
Well, they certainly could be public records in some cases, Your Honor, if they are not privileged or work product. But the fact that they may be public records doesn't make them relevant to this case. ORCP 36 says discovery in all forms has to be aimed at relevant evidence. And these two subpoenas are only aimed at.
But isn't the basis for this case, Ms. Bong is alleging that she's entitled to these public records that identify your professional relationship with the school district?
Yes, but, well, in the second case, yes. In the 25 case, yes. Not in the 24 case. But, Your Honor,
right, yes.
The point is, this is kind of an end run around the actual object of the case. In the 25 case, the issue before the court is whether or not the public records request was responded to appropriately. What she is asking for here doesn't go to that question. It goes to whether I am authorized or permitted, or whatever you want to call it, to represent my client. That's one basis for my objection.
Okay. So that forms the basis for relevance. Ms. Bong, do you want to respond to that?
Yes, it's absolutely relevant, Your Honor. Those questions or those records was what I requested in the public records request, which the school asserted that they had no knowledge of, but which Pace said they had possession of. So I'm at Pace for those records because Douglas County School District is supposed to have possession of those or have control of those records, which they have withheld from me. They did not assert privilege. They said they had no knowledge of those documents. That is not an appropriate response in a public records case.
And here we get to the problem, Your Honor. Ms. Bong is now arguing the substance of her case, not the subpoena and not the relevant documents that she claims are being sought.
But I think what she's saying is so what I heard you say, Mr. Mersereau, is the substance of this case is whether or not the school district appropriately responded, and their response to some extent was Mr. LaFontaine says I have no knowledge.
Right,
I don't know whether or not.
I'm sorry.
I don't know whether or not. That's okay. I don't know whether or not that response is a personal response or it's imputed to the school district or what, but I'll just imagine that it's on behalf of the school district. We have no knowledge. Okay. So Ms. Bong is saying these are relevant documents because they go to this theory that if Mr. LaFontaine is not allowing me the opportunity to see these public records by claiming no knowledge, when the court could impute that there was knowledge based on the fact that they exist.
I understand the court's fashioning a good argument for Ms. Bong here, Your Honor, but I just don't. If you look at the language in this subpoena, it is much broader than the public records request that is at issue in the case. She's asking for legal strategy, the scope of legal defense coverage, identifying attorneys, identifying other attorneys besides just in this case. So
You're talking about 16748, correct?
That's
25
correct.
CV.
Yes, and the other subpoena in the 24 case, Your Honor, directly asks for communications between me and my client. Obviously privileged.
Ms. Bong?
Well, it's not privileged if Mr. Mersereau is not properly procured or authorized to represent the school district.
You hold on. I'm going to shut this down. Mr. Mersereau is representing the school district. First of all, this is not the appropriate avenue to litigate that issue if you have a problem with it. Mr. Mersereau is representing the school district. You don't have any standing to object to that. Okay? So now from there, go ahead and respond to Mr. Mersereau's argument.
I'm sorry, what was Mr. Mersereau's argument again?
That the communications are
Effectively,
privileged.
And are we looking which communications? The one in KC? Why would the communications between Douglas County School District and PACE be privileged communications? It's an insurance company.
Right. And under the case I cited in my response, Your Honor, insurance materials are work product when they deal with legal strategy, which is the exact verbiage that's used in these subpoenas.
Okay, let's say they don't produce the legal strategy section of it, where I've also asked for requests for legal defense coverage or related assistance, approval, denial, or discussion of defense requests by Douglas County School District, engagement letters, assignments, and contracts of any law firm or attorney appointed by PACE to Douglas County School District. Why would these be privileged?
well, I think it's up to you to tell me why they're not, Ms. Bong.
They're not, because none of these involve any kind of legal strategy. It only involves the respondent and an insurer in terms of a claim. It has nothing to do with legal strategy. It has to do with appointment of a legal counsel and whether it's approved or denied according to the insurance policy.
Okay. Mr. Mersereau, anything
Well,
else?
if we're limiting it to literally just that topic, to just requests for counsel in a case that's been filed against an insured, I don't think those are privileged. And if the court wants to order that to be produced, if it exists, which I don't know, that's fine, Your Honor. But that's a tiny portion of what was asked for by both these subpoenas.
Ms. Bong, anything else?
I don't think so, Your Honor. I would like to raise the objection that irrelevance is not an option for an objection under ORCP 55. And if there was any objection, Mr. Jensen has not raised any objection or to quash or modify the subpoena within the 14 days of ORCP 55.
What are the, part of the problem is I think we need to do this for both documents, or both subpoenas, but why don't you, Ms. Bong, there were a lot of elements of this subpoena that you identified as not relevant, or as relevant, are not privileged. So what are you not objecting to, Mr. Mersereau?
Well, if we are narrowing the subpoena in the 24 case.
In the 24 case, yes, that's the one I'm looking at.
That's the one that I'm just seeing for the first time
No,
today.
I'm not. For some reason,
Actually, I think these are both in the 25.
the 25 subpoena is attached to the 24. How did that happen? Okay. So, just a moment. I'm looking at the motion to compel. For some reason, it's in 20, this is in 24 CV 52569. And I don't know why it got filed like this, but it is the 25 CV 16784 motion to compel within the 24 CV 52569 case attached. So I'm looking at the subpoena in 25 CV 161 or 784 inside of the 24 CV case. We're all on the same page?
Is that to Astika Welikala or Jens Jensen?
It's to Ashtika Walikala.
Okay, I'm looking at that as well, Your Honor.
What are your objections to this subpoena?
Well, if you look at it, it's very clear that it seeks privileged communications. It literally seeks communications between me and Mr. LaFontaine, who is my client, which is number one. Number two, me and any DC staff and DC 15 staff, again, privileged. Number three, I mean, Your Honor, I'm seeing this for the first time. This was not served on me, so I haven't
I
really.
did serve it on you, Mr. Mersereau.
Okay, well, here's what I would like to do. I would like for you to identify the language that is not objective. This is clearly asking for privileged communication, and it perhaps also exceeds the scope of the litigation that is before the court. But I want you all to narrow it down to, well, and actually, I'm not going to do that. What I'm going to do is I will grant the motion to compel to the extent that it does not call for privileged communication or anything, any documents that exceed the scope of the litigation before the court in either of these cases. Mr. Mersereau is to prepare those orders.
Understood, Your Honor.
Okay. Is there
Thank you.
anything else?
That will be it, Your Honor. Thank you.
Have a good day.
Thank you, Your Honor.